All right, with that in mind, real quickly, we've got a guest on the line right now, Byron Henry, who is an attorney. I asked if he would talk with us this morning. Saw something that's coming up in the Supreme Court that I thought would be of interest to everyone, and let's jump right into it. In Maryland, there is a 40-foot tall concrete cross that stands on a large grassy highway median, and for years it's a war memorial from World War I, and a plaque on the cross base lists the names of 49 area residents there who died in World War I. It's not easily read from the road, and getting to the monument it takes some time. However, in 2014, a gentleman named Stephen Lowe and two other area residents, including a group that includes atheists and agnostics, sued to challenge, arguing that the cross's location on public land violates the First Amendment's Establishment Clause. And anyway, it has worked itself up to the Supreme Court. Maryland officials are arguing the cross doesn't violate the Constitution because it has a secular purpose, but the American Humanist Association and others are saying it isn't secular, it is religious in nature and discriminates against others. Let's find out what Attorney Byron Henry has to say about that. Good morning, sir.
Hey, good morning. Great to be with you.
Well, thank you so much for joining us. You work with constitutional law all the time, and this is a big case, is it not?
Well, it's a big case for a couple of reasons. It's kind of the first big constitutional religion case involving our new justices, so that makes it big because you get to see how they are, if they agree with the majority, if they dissent, if they concur, if they call for some radical change in this area of the law, to kind of see where the court's going. It's also big because it seems as though there may be votes, because this area of the law is such a mess, and I put mess in quotes, just meaning there's a lot of different tests. It's kind of ad hoc. We've got Ten Commandments monuments on public grounds that have been upheld in some circuits and at the Supreme Court based on certain factors, and then some Ten Commandments monuments and other religious displays on public grounds that have been ordered to be removed because of circumstances or specific factors. And so bottom line is that you never can really tell how these are going to come out based on all the different theories and tests that the Supreme Court applies in this area. And this may be a narrow ruling which just leaves the cross up for under current tests and says this is an easy case, or it may be an opportunity to kind of reshape the entire area of religion in public life and how much the state is allowed to acknowledge religion without being considered endorsing it or running afoul of the Establishment Clause. That's really, somebody like me really is interested in not whether the court leaves the cross up, but do they change things? Do they move the law in one direction or another and actually rewrite this area of Establishment Clause jurisprudence?
Is the Supreme Court inclined to change things that much? I mean, I've seen where they kind of have pushed it. They keep pushing these things back. It doesn't seem like they've ever made a real push to say this is where we're headed.
Well, every tons of justices, liberal and conservative, have decried the current state of the jurisprudence. Of course, the liberals think it needs to be one way, and more conservatives and originalists think it needs to be another way. But certainly these doctrines and tests have become less and less tethered to the actual text of the Constitution, and that might draw the attention. Of course, it always draws the attention of the Justice Thomas. Justice Scalia was well known for saying that their Establishment Clause jurisprudence basically bears no relation or resemblance to the Constitution. And so you might have a Justice Gorsuch, maybe a Justice Kavanaugh, wanting to say, let's go back to first principles and let's get this right, because we basically strayed from the constitutional moorings of the text of the First Amendment. So there is an appetite to fix this area of the law in the originalist circles. The question is this the case that they'll decide to make their play and do it, or are they happy to just say, no, we've got case law that will support this cross staying up as basically a religious symbol that also serves the purpose of memorializing the dead, because it's kind of a universal symbol for that, and so we don't need to change the law to leave this cross standing. So it could be a whimper, this case, or it could be a bang, but I don't think the Supreme Court would have taken the case if they meant to allow the cross to be taken down. So I think the cross survives one way or the other. It just depends on, is it a narrow opinion on just this cross and its circumstances, or is it a broad opinion basically changing the scope of First Amendment jurisprudence?
Who are the players in all of this? I know the American Humanist Association, there's some atheists and agnostics, but there's also a Jewish organization on the side of taking the cross down, right?
Yes, I think that group is basically, trying to counter the idea that this is a universal symbol to memorialize the dead, because obviously for Jewish individuals of the Jewish faith or Jewish heritage, a cross would not be universal because it wouldn't be the symbol they would use. I think they have a point there, and let me just say that under current Establishment Clause jurisprudence, there is a good faith argument on the side of the plaintiffs in this case that this cross is unconstitutional. The area is in such disarray, this area of the law, with so many different tests and theories and opinions out there, that this is not a frivolous group just saying we don't want "In God We Trust" on the money, for instance, or we don't want "Under God" in the Pledge of Allegiance. This is a legitimate area of the law that is in dispute and not consistent and needs to be stabilized. And so they're making a good point that under current law, no one can argue that everyone uses the cross to memorialize their dead. It is a distinctly religious symbol specific to Christianity, a specific religion, and I can't really argue with any of those the facts. The Supreme Court's going to have to grapple with that. What the Supreme Court has said, though, is just acknowledging a faith or having prayers before legislative sessions that are sectarian or invoke Jesus' name or a Christian. That's not a violation of the Establishment Clause either. So you kind of have a vast array of opinions and viewpoints just kind of feeling away in the dark to figure out what violates the Establishment Clause when you're talking about these public monuments and what does not. The problem for the left is that so many of these have been around for so long.
Well, and they weren't put up by the government either, right? This was funds that was raised by, if I'm not mistaken, the American Legion there.
That's right. The argument here is that it's on not, you always have the argument that the government pays for it, right? So paying for it's a problem, for those under a certain view of the Establishment Clause. Then you've got the maintenance. Well, the government doesn't maintain it, but then you've got it on public land. So like the display at Christmas that's at the town square, or the Ten Commandments that sits down at the Texas outside in the square outside the Texas Supreme Court down in Austin, down here where I am, which the court upheld, by the way, as not being a violation of the Establishment Clause because it was one of a number of monuments kind of referencing the law and the underpinnings of American law. Here, the cross is on its own. So this is not a case where you have multiple things and a cross. You just have a 40-foot cross.
Right. However, it's not too far away from Arlington, if I'm not mistaken. And would this, if they take this down, does it affect some of the other memorials that might be at Arlington National Cemetery?
Well, certainly the argument from the defendants in this case and the state is that all government-maintained cemeteries and memorials contain distinct religious symbols, and it just happens that this is just one medium that has the cross, but there are other state-sponsored areas that have other things other than the cross. So I guess the argument is that do you have to have multiple symbols at every public site, or is it enough that a reasonable observer does not think driving down the highway that Maryland overnight adopted Christianity as its official religion just because there's a cross memorializing fallen service members?
Well, and that's the thing that's really no one who is maintaining that is using that cross for that purpose. I mean, there's no one saying we're a Christian state, if you will, because of that. It's just something that's been there historically since when? 1925, I think, right?
That's correct. And one of the interesting facts about...
Let's say you just bought a house. Bad news is, you're one step closer to becoming your parents. Soon you'll have a separate fridge in the basement, where extra groceries are exiled forever. Remember that frozen lasagna? Of course you don't. It's been down there since 2008. Good news is, it's easy to bundle home and auto through Progressive and save on your car insurance. Piece of cake. Behind the lasagna, it's very old. Progressive Casualty Insurance Company, affiliates, and other insurers. Discount not available in all states or situations.
I don't know how what's a time frame for this?
Well, the court rules on all of its argued cases, usually by the third Monday or last Monday, sometimes in June. So it could come out at any time after oral argument, as late as the last Monday or the last week in June before they go on their summer recess. So we have to wait until then. And if this is a big case, meaning the longer this case takes, that means there's probably a deep ideological split, which means the conservatives are doing something that is a bigger shift than simply allowing this cross to stay, because I believe there may be votes on the court other than conservatives to allow this court to remain in place under a very narrow, fact-specific ruling. They might even attract a Breyer or a Kagan in that opinion. But if the court is going to move Establishment Clause jurisprudence, so to speak, in one direction or the other, I suspect it will be a split decision, probably 5-4, and have a lot of writing, which would draw the case out probably closer to the end of the term.
Wow. All right, Byron Henry, thank you so much for joining us. Going to be fascinating. I'm sure we'll hear about it soon, and maybe we'll get a chance to talk with you again once the ruling takes place. Thank you so much.
You're welcome. My pleasure.